You're waiting for the federal gun rights restoration portal to open. But waiting is a mistake.
It is honestly the single biggest trap you can fall into right now.
And that is exactly why we are taking this deep dive today. Because look, the reality is the new online application system for federal gun rights restoration is going to open.
Oh, absolutely.
That is an absolute certainty. But there is a massive misconception out there about what is actually happening behind the scenes.
Yeah, people are completely misreading the situation.
Exactly. If you look at the flood of prep materials, legal guides, and, eligibility tools circulating online right now, one clear mission emerges.
Yeah.
We need to break down exactly what 18 U.S.C. Section 925C actually is, why the legal requirements are already locked in stone, and how you can get ahead of the massive line that is about to form.
Right, because it requires a fundamental shift in how you view the federal government's timeline. I mean, you have to treat this like an impending hard deadline, not just some, vague future event that you can react to later.
So let's get right into the mechanics of the situation. 18 U.S.C. Section 925C is the specific statute we are talking about. And the most important thing to understand, the thing that so many people are just entirely missing, is that 925C is already an active federal law.
Exactly. It's already on the books.
Right. It allows individuals to apply to the Attorney General to restore federal firearm rights that they lost due to a conviction. It is not a proposal.
Yeah.
It is not a new bill floating around in some committee. It already exists.
And that right there is the crucial distinction. People are confusing the legal architecture with the administrative process.
Yeah.
To really grasp this, you have to look at the history. The statute has been on the books for decades. However, back in 1992, Congress attached a rider to an appropriations bill.
Okay.
And that rider effectively stripped the ATF of the funding required to process these applications for individuals, so the law never went away.
Wow, so it's just a funding issue.
Completely. The fundamental legal right to petition for restoration remained perfectly intact. What vanished was the administrative plumbing to actually process the paperwork.
Okay, let's unpack this. Because I think people hear, the government is finalizing the rule, and they automatically assume the rules of the game are changing.
Right, they think the law itself is being rewritten.
Exactly. Think about it like this. Imagine you're waiting for the DMV to launch a brand new website for renewing your driver's license.
Okay, good analogy.
The actual rules of the road aren't changing. What a stop sign means isn't changing. The vision test requirements and the driving criteria are exactly the same.
Right, the core requirements are identical.
Yes. The only thing changing is the digital paperwork you have to fill out to prove you meet those criteria. If you wait for the new DMV website to launch before you even bother to learn the rules of the road, or check if your eyesight is good enough, you are making a massive mistake.
Yeah, you are fundamentally misunderstanding what is being updated. That is a perfect mechanical metaphor, honestly. The IT department is building the website, but the legislature already wrote the law. The burden of proof is established.
Right.
The only thing the government is finalizing right now is how the application workflow will be handled. They're, building the new online submission system, mapping out server loads, and figuring out the digital intake forms.
So the test is already written.
Exactly. Because the law is already written, the criteria you are going to be judged against are completely known right now.
So what does this all mean for you?
Yeah.
It means you need to know exactly what the law demands of you today. Because that burden of proof is incredibly heavy.
It really is.
There are 4 specific pillars written into federal law that you absolutely must prove to get your rights restored under 925C.
Right, and we need to be very clear that these aren't just checkboxes on some government form. They're comprehensive legal standards.
Yeah, they're not messing around.
Not at all. Let's walk through them mechanically. First, you have to prove that you are not a danger to public safety. Second, you must demonstrate that your record shows clear, sustained rehabilitation. Third, your reputation must actively support your application. And fourth, you have to prove that granting your rights back is actually in the public interest.
Man, those are dense. I mean, they sound simple when you list them out in a row like that, but proving them to a federal investigator is a completely different story.
Oh, absolutely. What's fascinating here is why these 4 specific criteria exist in the statute to begin with. The government isn't just looking for the absence of bad behavior.
Right. It's not just, I didn't commit another crime.
Exactly. When you look at these 4 pillars together, they demand a highly detailed, holistic picture of your life post-conviction. The first 2 pillars, not being a danger and showing rehabilitation, those are backward-looking.
Okay, making sense.
They examine your direct actions, your criminal record, and the measurable time you've spent out of the system. But the last 2 pillars, reputation and public interest, those are outward-looking. They examine how you interact with your community, how objective third parties perceive you, and frankly, what net value you bring to society right now.
But hold on, let me push back on this because I want to play devil's advocate for a second here.
Go for it.
I understand the first 2. I can pull a criminal record from my county courthouse to prove I haven't been in trouble, right?
Right.
I can maybe show I completed a specific program or maintained stable employment to show rehabilitation. But how do you practically prove an abstract concept like reputation or public interest before an application portal even exists?
It's tough.
Right. How do you put a PDF of reputation into a digital upload form?
And that right there is exactly why waiting is a critical failure. You cannot just click a button and automatically generate proof of a good reputation. Think of your application as constructing a bridge out of paperwork.
Okay, I like that.
If one foundational pillar, like public interest, is weak, the whole application collapses under federal review. You prove abstract concepts with hard, tangible, verifiable evidence.
So like character references.
Yes, but more than that, for reputation, a letter from your sibling doesn't hold much weight.
Right, they're biased.
Exactly. You need carefully curated character documents. We are talking about sworn affidavits from employers, community leaders, or even local law enforcement officers who know you personally.
So you're basically building a legal narrative through third-party verification.
Precisely. And for public interest, you have to demonstrate why restoring your rights doesn't harm society and ideally benefits it.
Interesting. Give me an example of that.
Well, maybe your employment requires a firearm, or maybe you are heavily involved in community service or outdoor conservation efforts. Gathering that level of hard, compelling evidence takes immense time.
I bet.
It takes weeks, sometimes months, of tracking down old court dispositions, contacting former supervisors, drafting affidavits, getting them notarized, and formatting everything perfectly. Yeah. If you wait for the portal to open to start figuring out how to prove your reputation, you have already lost the race.
Which brings us to the most urgent reality of this whole situation. The bottleneck.
Oh, the bottleneck is going to be massive.
We have to be incredibly clear about this with you. This digital portal is going to happen. It is opening. And when it does, it is not going to be a slow, steady trickle of applicants.
No, not at all.
Yeah.
If we connect this to the bigger picture, you have to look at the administrative reality of federal agencies. Because of that funding freeze back in the 90s, you have decades, literally decades of pent-up demand.
It's crazy to think about.
There are millions of individuals who have been living completely law-abiding lives, waiting for a viable path to rights restoration. When this online workflow finally goes live, millions of people are going to rush in at once.
Millions of people all hitting the exact same digital system at the exact same time. And let's be real about what happens after you hit submit.
Right.
The server might accept your PDF instantly, sure, but a human investigator still has to review it.
Exactly. Every single one of those applications has to be scrutinized. A federal employee has to cross-reference state databases, verify the authenticity of your affidavits, and evaluate your narrative against those 4 statutory pillars.
It's not automated.
No. A sudden influx of millions of applications is going to immediately create a historic bureaucratic bottleneck. We are talking about an administrative logjam of epic proportions.
So when you hear people online or in forums saying, I'm going to wait until the final rule comes out to see what I need to do, they might think they are being strategic.
Yeah, they think they're playing it safe.
Right. They might assume that waiting to see the final shape of the digital form is the smart play.
Yeah.
But mathematically, they're guaranteeing that they will be stuck at the very back of a line of millions of people.
It's a fundamental miscalculation of the landscape because, again, the statutory requirements are fully known.
Yep.
The physical documents you need to prove those 4 pillars are known. The preparation process is entirely clear right now. The smart strategy isn't waiting to see where the upload button is located on a web page.
No, definitely not.
The smart strategy is pulling your court records today, It's securing your notarized character documents today. It's building your legal architecture right now.
So that on day one, minute one, when that website goes live, you aren't scrambling to figure out how to define public interest to an investigator.
Right, you just upload your file.
You are just hitting submit. Being prepared isn't just about being organized here. In a massive bottleneck situation like this, being prepared is a strict strategic necessity.
It is the defining difference between having your case reviewed in the first wave versus waiting 3, 4, maybe 5 years for an understaffed federal agency to dig out from under a mountain of files to finally pull yours from the stack.
Okay, so we know the stakes, we know the law is set, the 4 pillars are unmoving, and the historic bottleneck is coming. The obvious question you are probably asking right now is, how do I actually do this?
Right.
If I shouldn't wait, what tangible steps can I take today to ensure I'm in that first wave?
Fortunately, you don't have to guess, and you don't have to start from scratch. There are specific tools available right now designed exactly for this proactive preparation.
Okay, where do we start?
The first step, logically, is simply figuring out where you stand. You need to know if you even qualify under the baseline of the statute before you start tearing your house apart looking for old court documents or paying notary fees.
Right, and that is where the online eligibility tool comes into play. If you look at the resources circulating right now, this is a highly utilized starting point.
Extremely popular, yeah.
It takes just a few minutes to run through, and it helps you immediately understand your options based on your specific background.
But it's important to understand how it works. It isn't just a generic online quiz.
Okay.
It algorithmically maps your specific conviction history and timeline against the statutory disqualifiers explicitly written into 925C and other federal firearm laws. It removes the guesswork.
That's huge.
You aren't operating on assumptions about how a 20-year-old record is classified today. You are getting a clear, data-driven baseline.
But wait, how can a generic online tool give you a definitive baseline on a complex federal statute? Isn't every case completely unique?
Well, every life is unique, sure, but the federal disqualifiers are highly rigid. The statute has very clear boundaries regarding the types of convictions, the jurisdictions, and the timelines that mandate federal prohibition.
I see.
The tool simply filters your inputs through those rigid legal boundaries to tell you if a pathway exists under 925C or if you are statutorily barred.
And the data on this tool is really telling. There have already been over 3,901 eligibility checks completed.
That's a lot of people getting ahead of the curve.
It is. People are out there actively mapping their eligibility right now. And here's where it gets really interesting.
Yeah.
98% of the people who use this tool found it helpful. That high of a utility rate on a complex legal issue is a strong indicator that gaining early clarity is the right move. And for $9.99, you can actually unlock, download, and print a fully personalized assessment report. That gives you a physical roadmap of your specific standing.
It provides vital situational awareness at a very low entry point. Once you have that baseline, once you confirm mathematically that you are eligible to proceed, you move to the heavy construction phase.
Gathering the specific evidence for those 4 pillars.
Exactly. And that is where the second major resource comes into play, which is significantly more comprehensive.
Yes, the Workbook. Specifically titled 925C, Made Simple, the Ultimate Federal Gun Rights Restoration Workbook. And again, looking at the community data, over 12,282 of these workbooks have already been purchased.
Which is incredible.
It means there are well over 1,000 people out there right now who are actively building their cases and are miles ahead of the crowd.
The reason it's being heavily utilized is because it translates the abstract demands of the federal law into an actionable physical workflow. Right. It takes those lofty pillars, rehabilitation, reputation, public interest, and breaks them down into strict, manageable tasks.
And the resources circulating for this are highly recognizable too. I mean, the main workbook people are using literally has Donald Trump giving a thumbs up next to a blonde woman with the U.S. Capitol building, the scales of justice, and a scroll showing "We the People" from the Constitution on the cover.
Yeah, it's very distinct.
It's very much leaning into the constitutional rights imagery of the movement. But beyond the bold cover, what's actually inside the checklists is what really matters. It gives you step-by-step instructions that thoroughly explain the entire restoration process.
Exactly. The visual identifier helps you find it, but the core value is entirely in the methodology. It includes actual checklists and worksheets that show you exactly what materials to gather.
That's so helpful.
It details what specific documents you need to prepare and, crucially, how to actually position your application narrative so that it directly answers those legal standards. It basically functions like a project management tool for legal discovery.
And positioning is everything, isn't it? It's not just about dumping a disorganized pile of 50 papers on a federal reviewer's desk and hoping they figure it out.
Oh, please don't do that.
Right. It's about presenting a cohesive, undeniable narrative that proves you meet the criteria of 925C. The worksheets guide you in structuring that narrative long before the digital portal even exists.
By working through those pages now, you are essentially pre-filing your application in your own living room. You are conducting a stress test on your own evidence.
Yeah.
The biggest advantage here is finding the gaps in your documentation while you still have the luxury of time to fix them.
Right. If you realize you're missing a key court disposition from a different state from 20 years ago, you want to find that out today.
Exactly.
When you have the time to calmly call the county clerk and wait 2 weeks for the mail, you absolutely do not want to find that out on the day the portal opens, while 2 million other people are clogging up the county phone lines trying to do the exact same thing.
That is the entire premise of proactive preparation. You are securing your evidence before the system is under stress. You are buying yourself a massive strategic advantage.
So, to bring this all together and wrap it up, the situation is remarkably clear, even if the general public perception is muddy.
Very clear.
The law, 18 U.S.C. section 925C, did not change. It is an active statute. The 4 massive requirements: you must prove that you are not a danger to public safety, that you are rehabilitated, that your reputation is solid, and that your restoration is in the public interest. Those did not change.
None of it changed.
Only the digital submission process is being finalized right now.
Which leaves you with a stark binary choice regarding how you handle the coming months.
Exactly. You can wait for the final rule on the portal to drop, scramble to figure out what documents you need, and get stuck at the very back of a line of millions, completely paralyzed by a historic bureaucratic bottleneck.
A nightmare scenario.
Truly. Or you can act now. You can use the eligibility tool to confirm your standing, grab the 925C Made Simple workbook to map your strategy, pull your records, build your indisputable case, and be fully prepared to hit submit the very second the doors open.
You know, this raises an important question, though, one that really makes you look at the long-term landscape of this entire process.
Look at that.
Well, we know the bottleneck is coming. We know millions will apply. But consider this. Once this digital floodgate finally opens, how is the federal government's bureaucracy actually going to handle an unprecedented wave of fully prepared, legally sound, intricately documented applications submitted on day one?
Oh, wow.
Right? If thousands of people use these methodologies and submit mathematically perfect applications immediately, could the sheer overwhelming volume of undeniable proof fundamentally force a change in how federal background checks and restorations are processed in the future?
That's a great point.
It's a systemic shock to the bureaucracy that we have quite literally never seen before.
It is going to be incredibly fascinating to watch that unfold, that is for sure. But the only way you get to watch it from a position of strength is if you start building your case today. The tools are there. The law is clear. Stop waiting. Start preparing. Thanks for joining us on this deep dive, and we'll see you next time.